Welcome back to a new post today. Today, let's discuss something important with regard to the landmark judgment given by the Supreme Court, the benches headed by J.B. Pardiwala and Madhavan regarding the governor's power of veto with regard to state bills that is passed by the state legislature. So the Supreme Court went on to define timelines for passing of the bill that is sent to the governor for assent and also for reservation of the president. It also spoke about the president's pocket veto with regard to the state bills as well. This is a landmark judgment because there have been problems in states where there are other parties who are ruling the government and the governor who comes from the ruling party of the center. There have been clashes with regard to reservation of bill, unlimited time taken for giving assent to the bill and also for reserving the bill to the president after it has been reconsidered by the state legislature. Therefore, the Supreme Court has gone into these points in this landmark judgment, putting a timeline to the governor and the president within which they have to give assent to the bill, or the governor can reserve it for the president, therefore giving a win to the parliamentary system of procedure in the government and also democratic rules and regulations as well. So by exercising it, the Supreme Court did so by exercising its extraordinary powers under Article 142 of the Constitution, which deals with enforcing of decrees and orders by Supreme Court to do complete justice before a matter that is pending before it. And many a times the Supreme Court has used Article 142 to do complete justice in many cases. This time it's with regard to the governor. By using Article 142 and arming itself with these powers, the Supreme Court virtually granted assent to all the 10 bills that were reserved for consideration by the Tamil Nadu governor R.N. Ravi, and the Supreme Court expressed its displeasure on the actions of the Raj Bhavan and the manner in which the governor was acting as a hindrance to the functions of the legislature, that is the lawmaking body at the state level. The bench of Justice Pardiwala and Mahadevan invoked Article 152 to take over the role to do complete justice and to define sparingly the powers of define the governor's powers sparingly with regard to the passage of the bill. The apex court advised the governors not to create roadblock and choke the state legislature. The Supreme Court outlined the powers and the timeline for the governors to decide on the bills passed by the legislature. It said the governor has to decide on the bill, to give its assent, withhold its assent, or send back the bill for reconsideration under Article 200 within 1 month. And if the bill was sent back after reconsideration by the state legislature, the governor had 3 months time to reserve it for the president. And if the bill has come back to the governor and he does not reserve it for the president but his assent is mandated, then within 1 month the governor must give his assent, and also the governor cannot withhold the bill after once the state legislature has sent it back for after reconsideration. The top court in its ruling stated that the president also does not enjoy absolute veto over the bills passed by the state. The apex court also mentioned that the president must decide on the bills within 3 months time. Now this is also not mentioned in Article 111 or 111 of the Constitution, and states that and 201 and states that stated that the states can approach the court if the decision is not taken within the prescribed timeline, therefore bringing in judicial recourse to the state in matters of legislative issues between the governor, that is the head of the state, and the head of the government, that is the CM, the Council of Ministers. The Supreme Court said that it is not open to the governor to reserve the bill. As a general rule, it is not open for the governor to reserve a bill for the president, and after the bill has been represented to the government by the government after being passed by the assembly, the governor has to give his assent. And the Supreme Court took the help of the Shamsher Singh versus State of Punjab 1974 ruling, where the Supreme Court stated that the governor is bound by the aid and advice of the Council of Ministers in exercising his powers as a rule and can only exercise discretionary powers as an exception. Let's go further and look at the landmark judgments that the Supreme Court has gone into various powers that are exercised by the governor. The Supreme Court also said that we are left with no choice but in the exercise of inherent powers under Article 142 of the Constitution to declare that these 10 bills have been deemed to got an assent by the governor, and therefore that now they are no longer with the governor and they are deemed to have assented. That means they are passed by the governor. The Supreme Court went on to say that we are not undermining the office of the governor, but he must act with due deterrence to the settled conventions of parliamentary democracy. He must perform his role with dispassion, guided not by considerations of political expediency, but by the sanctity of the Constitution and the oath that he has undertaken. He must act as a catalyst and not as an inhibitor. This is what Justice Pardiwala and Mahadevan went on to say. Let's look at some of the important landmark rulings of the Supreme Court, which went into some of the important powers of the governor and its functions. Now, apart from Shamsher Singh versus State of Punjab in 1972 4-4 ruling, the Supreme Court stated that the governor is bounded by the aid and advice of the Council of Ministers and can only exercise his discretionary powers as an exception. In 2006 landmark ruling of the Rameshwar Prasad versus Union of India, the court held that the individual opinion of the governor cannot be the ground for imposing of president's rule. Even when it comes to the judicial powers of governor in granting pardons and mercy, the Supreme Court said in 2006 that in the Rameshwar Prasad versus Union of India that the decisions will be subjected to judicial scrutiny. In 2016, in the Constitution Bench of the Supreme Court, in the Nabim Rabia and the Bimang Felix versus Deputy Speaker and the Arunachal Pradesh Assembly case, expressed that the power to summon the House is not solely vested in the governor. The Punjab government in 2023 had moved the Supreme Court against the governor's Banwari Lal Purohit over his refusal to summon the budget session of the Vidhan Sabha. When the House is in session, it is the Speaker who can call for a floor test, but when the Assembly is not in session, the governor's residuary powers under Article 163 allow him to call for a floor test. This is what the Supreme Court had said. There are two, however, apart from these, there are two areas that of the role of the governor which have not been scrutinized till now. One is sanction for prosecution against the state government officials, and two, the power to invite political parties to form a government. The governor's role in the government formation had come into scrutiny in 2017 when the Karnataka governor Viju Baiwala was questioned over his decision to invite the BJP, the single largest party, to form the government over the numerically stronger post-poll alliance of Congress and JDS. While the court has called for floor tests as an immediate solution, the larger questions of the law are still pending with the court. So this is a landmark judgment defining the boundary, the timeline within which the governor and the president have to give assent to the bills, therefore reigning in the legislature's power, and also accountability of the governor and the president to, if they violate their constitutional duties, to the judiciary of the country. So this is a landmark ruling, and also many states will be definitely. Kerala was the first to hail the ruling of the Supreme Court, because it is also dealing with the same problem with regard to governor reserving the bills for the president assent and not giving assent within a timeline. Therefore, previously Telangana has gone through the same when we had Tamil Sai as the governor as well. Bills were kept for almost 9 months to 7 months and even more than that as well. So these are the issues that were taken up by the Supreme Court, and the landmark ruling is hailed by many of the states. So waiting, but however, Article 142 says that this power of the Supreme Court has to be now enforced by a law or a presidential order. So we have to wait and see whether the constitution is going to be amended to include timelines by the parliament, and if they do so, it's well and good. Also, before if the as the parliament is not functioning now, the president can as well bring about an ordinance as well and a presidential order as well. So these are the wait and watch issues. But yes, these are the important points I wanted to touch with regard to the Supreme Court landmark judgment on the timeline set for governor's veto power with regard to state bills and the president powers with regard to the state bills as well. If you did, please do like, share and subscribe, and don't forget to comment at the end of the video. I shall see you in my next post. Until then, it's very happy learning.